A very graceful good afternoon to our most valued speakers in International Conference on Comparative Law 2022. Amity Law School, Noida, in collaboration with School of Business and Law, Edith Cowan University, Western Australia, welcomes everyone in keynote session 4 of this conference. Myself, Suparna Vinayak, Assistant Professor, Amity Law School, Noida, will be moderating the session. We have amongst us in this August gathering Dr. Subhajit Basu, Associate Professor, School of Law, University of Leeds, UK. To begin with his career, he is an academic lawyer, Associate Professor in Information Technology Law at University of Leeds. He has been teaching and doing research on the regulation of the Internet, including issues related to privacy, data protection, freedom of expression, and also e-commerce. He aims to explore the challenges that the Internet has created in transforming everyone's lives, especially in the area of governance and in legal framework. Dr. Subhajit Basu is further keen to examine how we can update our legal framework so as to protect privacy and equip the public with the knowledge needed to make informed choices. I request you, sir, to address this gathering.
Thank you, Suparna, for the kind introduction. Thank you for inviting me. I was quite excited when I received the invitation. It's a good morning from here in Leeds. It's a grey morning, as usual, in England. My research is focused, as Suparna said, is focused on regulation of emerging technologies. And for past couple of years, I have been looking into the area of regulation of big techs. So this lecture is about regulation of big techs. I'm not going to provide you with any solution, but perhaps I will be able to raise some questions and some pointers for you to think about. Now, almost all political, legal, and social sectors agree that the current legal landscape is inadequate for dealing with challenges presented by big tech and social media companies. The question, which is perhaps in everyone's mind but rarely gets mentioned, is it possible to develop a coordinated international approach to regulate big techs? The world's largest platform technology companies, Apple, Microsoft, Amazon, Alphabet, Meta, they operate with Machiavellian aggression. The ease and the speed with which these companies can scale up their activities are simply astonishing. These companies are accused of engaging in trade monopolies, and they have had an unbelievable profitable few years. Their profit runs more than some countries' total GDP. We know this because Facebook's whistleblower, Frances Haugen's revelations that Facebook, which is now known as the parent company is called Meta, knowingly used algorithms to target advertisements towards vulnerable children. They even profited from disinformation and hateful content. This unchecked concentration of power in digital economies is having a negative impact also on our governments and other businesses. Just for a moment, think about Facebook's Cambridge Analytica scandal. Or just think about COVID-19 conspiracy theories, the anti-vax conspiracy theories running rampant on social media. Think about Google's preferential ranking of its comparison shopping service in its search result pages. The Cambridge Analytica scandal has taught the world that data can make or break democratic elections anywhere in the world. These companies have a worrying level of influence on every part of our life and without accountability. Interestingly, the power exercised by these companies could be classified in different ways. For instance, you can see these companies um, as having policy powers. It's a form of soft power, allowing them to influence public discourse and policy discussions. Equally, it is possible to think that these companies have a form of media power. This is because Google, Twitter, Facebook, Instagram, they have the power to influence opinion. They have the power to control what content their users see when they see it. And this method of self regulation allowed big techs to cherry pick what they want to control and what they want to uh, ignore. As much as I love the idea of Twitter banning Donald Trump, it raises question: can they do it? Should they do it? There is no right to be not to be deplatformed, but with the impunity Twitter did uh, raises question. So in my mind, it's no longer a question if we should regulate big tech, but rather how do we regulate big tech? And there's a lack of oversight mechanism, and we have paid a cost because of this lack of oversight mechanism. We have a patchwork of laws and industry self-regulation that lack both transparency and coherence. But regulators worldwide, and particularly during the time of COVID, they have waken up. Okay, they are developing legislation designed to encourage competition. However, to regulate big techs, governments first need to determine the appropriate regulatory scope for the industry. They need to define what is within the regulatory parameter and what is outside. And this is crucial because governments need to engage with both the regulated and the unregulated areas. We have seen that several policy initiatives emerging from China, European Union, United States in the last few years in the areas of competition law, data protection, business conduct, financial stability. But these efforts have been disjointed and they actually benefited the big techs. I think European Union, don't think I'm being biased with towards the European Union, but sometimes they do things good. European Union is probably a bit more at an advanced stage when it comes to proposing effective legislation. European Union came up with a legislative proposal in 2020 aimed at preventing large online platforms, the so-called gatekeepers, from abusing their market power. Under the Digital Markets Act, designated gatekeepers will have a set of obligation and they could be fined up to 10% of their worldwide turnover in case of non-compliance. Although this list of gatekeepers has not been published yet it is understood the big five will be definitely included. And after years of doing nothing, China has recently started reshaping its technology regulation landscape. Tech giants like Ant, Didi have been targets of antitrust probe. Just a few years ago, China's tech companies were immune to regulation. Their CEOs were idolized by the Communist Party. They were the darlings of the government. Something has changed. Now there is a growing trend in China to rein in. For years, the tech companies in China were allowed to grow in a nurturing policy environment with no competition from overseas tech giants. These companies exploited the legal gray areas in China. And even when regulators tried to govern, for instance, the e-commerce law that was enacted in 2019, the companies successfully lobbied for softer guidelines. But now China's aim is not substantially different from those calling for more antitrust action in the United States and Europe. China's largest tech platforms have used their power to destroy small businesses. So instead of helping the government to solve social instability, inequality issues, these Chinese tech companies contributed to social instability. And what is striking and true in Chinese form about this approach is the speed of regulation. In addition to the antitrust regulation, China is looking into cybersecurity, they're looking into data protection issues, consumer protection issues. They are even breaking down big companies like Alibaba. Here in UK, we are expecting that the government will progress fast this year. Our online harms bill, which was first introduced in 2018, is going to be a big priority. But our government wants to make changes to the data protection law, wants to be more industry friendly, whatever that means. Post Brexit, we seem to have a much more liberal attitude towards regulation. One thing I can tell you, please remember, big techs are different from anything we have seen before in the past. Previous monopolists were not involved in regulation of speech or dissemination of knowledge that shapes public opinion. Big techs are the editors of public sphere. They are both the vehicles of the speech and they are also the controllers of the speech. We cannot, we cannot expect that our old remedies would work. Classic antitrust or competition law obviously will play a part, but it's not enough. The reason is very simple. To regulate a public sphere, one needs to address more than simply the market. And India is a good example to talk a little bit about this a little bit more. In India, this problem has a different dimension apart from India wants to tax the tech giants, which is quite justifiable. But the gap between big techs and its commitment to democracy in India appears to be widening. Just on 2nd of February this year, Indian government officials had heated discussions with Google, Twitter, and Facebook for not proactively removing what the government described as fake news from their platform. While the Indian constitution guarantees freedom of speech and expression, it also bans expression or publication of anything that risks India's security, public order, or decency. The government of India introduced a long list of IT rules last year, I think in 2021, last year. These rules require social media platforms to warn users to not to post anything that is defamatory, obscene, causes invasion of privacy, encourages gambling, harmful to children, false or misleading. It's a long list. The problem is some of these provisions have not been clearly defined and they can violate freedom of speech and expression and can even lead to censorship. As a free speech advocate, I would say that these rules are prone to politicization and could target government critics. The question is, if platform giants do not follow government of India's regulation, they lose a market of 1.3 billion people. And that is something they are clearly not willing to risk, regardless of the price Indian citizens themselves will pay. So finally, so is it really possible to develop a coordinated international approach to regulate big techs? We know regulations are a result of both political interest and functional interest. So global consensus around both seems to be impossible to achieve, at least from my point of view. The best we could hope is to the situation. EU's regulatory framework could provide clarity and guidance for the rest of the world to balance concerns of access, competition, and privacy. However, there's a real risk that this new regulation will boil down to a list of bans, which I absolutely oppose. Finally, I want to conclude by saying a regulation that is ineffective in meeting its objective can just be as harmful to government, businesses, consumers, citizens as no regulation or overregulation. Thank you.
Thank you, Basu sir. I am really expressing in this manner that rightly said that data protection and privacy should not be limited only to the disclosures which are being done with reference to leading to another dimension which can lead into coherency and self-regulation. So I request now Mr. Amir Faruqi to be here, who is a legal counsel to the French Embassy in India, appointed by the letter of ambassador since 2017. Bignon Lebroy is one of the only French business law firms established in India. As a founding member of the India desk, Mr. Amir Faruqi have been developing since 2013, a practice dedicated to heightening the business relation between France and India, while advising entities that aspire to set up ventures between India and France, where he had started his career in the telecommunications sector as a business lawyer at Orange in 2013. I request you to address us, sir.
Thank you for this opportunity, and good afternoon to everyone. And thank you for this kind of introduction as well. I would not be going into such a controversial or politicized subjects. I believe like your symposium is about comparative law, and I'm actually, as you introduced me, on a daily basis comparing French corporate law with Indian corporate law, because I'm a corporate lawyer. And I think for me, it's important to share with you and whoever your listeners, I think students as well, would be how I see and why I see comparative law as an asset to me. So basically, my clients are mainly French companies or French investors having interest in India. And it's really important for them to have someone who's able to understand their French laws and explain them Indian laws through what they already know, actually, especially in their own language. Okay, so now I'm not claiming to be an Indian law specialist, but through what I could learn about Indian laws from my last 7 years of experience on Indo-French transactions, I could see that the main principles always remains the same, and only the divergence would come in the implementation of the principles. French laws are based on a civil law legal systems, where Indian laws follow common law. Okay. It's quite known to everyone. And surprisingly, you would see lots of similarities. For instance, in contract law, you would see lots of similarities because both systems have their genesis into Roman law of contracts. For instance, in case of force majeure, a notion, something that everyone was talking about during COVID times, you would see that the idea of the force majeure in French law and in Indian laws are the same. Only the implementation of the idea is different through divergence in case laws and damages that will be granted in case of force majeure. Now, if we talk about more specialized laws, for instance, taxation, employment laws, you would see that the laws are completely different. And that's even the prevailing issues on which you would see cross-border treaties. And these cross-border treaties would be taking into consideration these differences between each country. And often these are also the legal issues that are the most of the time prone to litigation, where one country's court will have a different interpretation from the other court's country interpretation. And that's even actually the prime reason for arbitration proceedings, to include teams of lawyers that will be coming from every country that will be involved in the case. And I would say that if you're not afraid of constantly learning, then comparative law will be certainly an asset for you. And there's no doubt that the best lawyers are the one to keep on it. They are the one that keep on extending their knowledge and that are keeping their curiosity high, actually. So now coming to French corporate law and the types of companies, and if you compare them with Indian laws, you'll be able to see that, for instance, a French Société à responsabilité limitée and Société par Action Simplifiée. There are types of French companies. They're close to an Indian private limited company, with, of course, some peculiarities for the powers and duties and even the governing bodies. Okay, but this is going to take me time for me to elaborate on this. But what I'm actually trying to say is that through the studies of both laws, we can actually, without any doubt, bridge the gap between France and India, especially when you are well versed with both laws. You actually develop the ability to make French people and Indian people understand each other without even trying to bend one over the other. Okay. And again, if you keep some sense of curiosity, you will also be able to identify loopholes. Just last week, I was discussing with one of my colleagues insolvency procedures. So in France, if you're a director of your company, neither members nor the directors or even the family members can't buy back the assets of a company that is going into liquidation. Okay. And the same goes for your cousin. But in India, it seems that the cousin does not come into the scope of the people that are forbidden from buying back the assets of company that are going into liquidation. So here, really through comparative law studies, you're even able to find loopholes that will be great assets, not only to you, but also to your clients. I'm actually not an academician, sorry, and I may have made some shortcuts, I would say, but comparative law is, to me, extremely important if you're working on cross-border transactions for the many reasons I've explained before and previously. And on this note, I'd like to thank you for listening, and I'll be happy to take any questions if there are any.
Thank you, Mr. Amir Faruqi. Indeed, multiple inferences can be drawn on the force major clause, and that is so vital in COVID-19 times where interpretations were being drawn to fetch the compensation and the damages. Thank you, Mr. Amir Faruqi, for this, for the practical insight, how the comparison is to be drawn while addressing the issues. Thank you, sir.
Okay.
Mr. Sonam Sharing, I would like to invite Mr. Sonam Sharing, who is a senior lecturer, Faculty of Law, JSW School of Law, Bhutan. He has been teaching the procedural laws, contracts, media, and privacy laws. He holds masters in the law from George Washington University, DC, USA, and LLB from New Law College, Pune, India. Prior to this, he has worked as a parliamentary committee secretary and legislative officer for the National Assembly Secretariat of Bhutan. He also worked as legal advisor, public prosecutor, official media spokesperson, and trainer for Narcotics Control Bureau and Bhutan Narcotics Control Authority. He has been involved in drafting the number of bills, bylaws, and policies for the Bhutan. He has extensively written numerous papers on law and presented in both national and international conferences. Further to this, he has been writing for last 1.5 years and on a weekly legal outgoing in Bhutan's oldest and largest national newspaper, where most of the ops and eds are focused on the social justice. I welcome you, sir, and would like to have your view on the same. Mr. Sharing.
Thank you very much. And I would like to wish everybody a very good afternoon from Bhutan. And the weather is very good here. We are having a sunny day here today. And today my presentation is mostly going to be much more of a paralegal kind of a thing, not very much focused on law. I am going to, in fact, talk a few things about the influence of social media and COVID-19 in Bhutan in terms of governance, in terms of accountability, in terms of citizens' participation. But before that, maybe I thought, I think a lot of people may not know where the Bhutan is, unlike France or United Kingdom, which is well known. Bhutan is a tiny nation, in fact, situated between India and China. We actually share a border with West Bengal, Assam, and Arunachal Pradesh with India. and is a has a population of less than 1 million people. So obviously very small country. And Bhutan is most of the time it's known as like the last Shangri-La, or it's also known as so happy country, only because Bhutan has been pursuing important goal known as gross national happiness. This mandate of the state is to ensure that happiness of the people. And Bhutan's first case of COVID-19 came on 6th of March 2020 with first American tourists who got, who tested positive here in Bhutan. And since then, we have had a number of COVID cases. And as of yesterday, we had around 6,000 COVID cases, 9,200 COVID cases since 2020. Of which 6,000 has recovered and around 3,000 are still active. So we just had lockdown a few weeks ago, and some of the districts are still under lockdown these days. In terms of vaccination, I think we have around 90%, 12 years and above. So it has already gone up to 90%. And in terms of booster dose, it's around 95%. And death is around 5 people. So 5 people have succumbed to the COVID-19 here in Bhutan. Now, one of the aspects of Bhutan that you may know is that Bhutan opened to television and internet only in 1999, unlike most of the world. So which means Bhutan's journey towards technology, journey towards social media is fairly very new. In fact, telephone itself was open, internet itself was open only in 1999. We had the television sets only in 1999. In 2003, we had mobile phones, and by 2008, we had 3G, and in 2014, we had 4G. In 2022, we have now 5G, just recently launched. Now, in terms of use of social media, the most common social media used here in Bhutan would be Facebook, Instagram. We have Twitter users, we have LinkedIn users. We also have a social media which is not generally used in India, known as WeChat, popularly used by Chinese population. We also have WhatsApp, widely used. We have TikTok. Now people use Likey, people use YouTube, people use Snapchat, and Telegram is also quite, I think, gaining popularity here in Bhutan. So these are the major social media that is being used in Bhutan. But interestingly, till COVID-19, government was not that much on social media. Government was there on just to post some photos. But when the social COVID-19 hit Bhutan, it suddenly the whole governance went on to social media, mainly on Facebook. They use Facebook as a means to communicate with citizens. And from that day onwards, and gradually, the first was the Prime Minister's office, and then I think whole of the governance moved to the Ministry of Health, then regulatory agencies. Then it has gone up to every level of government onto social media. And if you go through this journal, the journey, I have been doing some research and I'm trying to compare with other countries. For now, this is a preliminary study. And if you look at that component, initially government, in fact, used press briefings daily. Then after some time, they thought maybe we should use more social media. So they went weekly, and then they went monthly. And by third lockdown, we hardly had any press briefings. Everybody had to wait for social media to get the information. So whole of the governance was on social media. And interestingly, Bhutan does not have a separate legislation on cyber law, particularly on social media. We do have a law known as Information and Communications Act in 2018, which repealed 2006. But these are more or less, I think I could say, similar to Indian Information Technology Law 2000, and not much so much on social media, but more to do with other aspects of the technology. But the government still thought the social media is the best platform to do that. So in terms of governance, the whole governance, government issued lockdowns, government issued relaxations, government issued notifications of vaccination sites. Everything went on social media. So whole of the governance, in fact, not just limited to COVID-19, but whole of the governance since the COVID hit Bhutan, it went on to social media. And then as a result, I think citizens had to be on social media to get the correct information or the fastest information. And then people had to rely fully on social media for news, updates, and everything. And mainstream media became much more like a post office, because more mainstream media and netizens were competing each other to get the updated version. And as a result, the mainstream media, in fact, did not have much impact in terms of dealing with the social media, dealing with news on COVID-19, but more to do with social media. So as a result, the platform that then gradually became its government-citizen conversation bridge became a kind of a communication channel between the government and citizens. So with the government, everything online, the citizens also went online. If they are frustrated, they showed all their frustrations online. Hundreds of thousands of grievances were posted, on the Prime Minister's, post, on the Ministry of Health's post, some with identity and many with anonymously, because Bhutan is a small society and nobody wants to upset the other person. You know who is on the other end, but at the same time, you can't hold your things. So you want the government to be accountable. And as a result, I think groups were formed, both officially and unofficially, and districts, regions, all were divided into different components. And everybody, in fact, went onto social media with both the government and the private, the citizens. The consumers use social media to get attention of the government on escalating, essential, prices for the goods. And then mainstream had to media, in fact, pick news from the social media itself. So one of the major factors, I think, that the government has faced or the nation has faced is fake news, the numerous rumors, in misinformation on COVID-19. Somebody just said, somebody died. Just few days ago, somebody just circulated a news saying that there is a lockdown in the capital, and that news, spread across whole of the nation. And then suddenly the Prime Minister comes and say that there is no lockdown. So these are some of the, I think, immediate threats that the social media is imposing. This leads to, I think, panic and wrong information to citizens. So people rush to do shopping because they think there is a lockdown. And as a result, it has in fact contributed in terms of spreading COVID, because a large gathering of people come out and do shoppings. And the other, I think, drawback of this challenge of social media is we have a lot of villages in the country. A lot of rural people rely on, the government on information. But since it came on social media, not many villages are on social media, and not many people who couldn't write, who couldn't read, were in fact in a way neglected of their right to information. Their rights were not be protected properly, because government was always on social media, and some of these people were not on social media, particularly on Facebook. And mainstream media reach is not wide enough in rural areas. So as a result, I think one of the major pitfalls or the loopholes of this is that it has affected the rural people much more than the urban people, because any wrong information, if they got, it is very difficult to rectify on time. The other, I think, major challenge this would face is that Bhutan's reliance, the government and the people's reliance on tech giants is too much. In fact, we are totally on the tech giant. If you go to government websites, none of this information exists, which means that tomorrow, if something happens to Facebook, there is no channel, there is no alternate way to, in fact, find out what is the most updated version. We have lost everything, probably. So I think these are some of the major challenges as a country faces. We are too much on a tech giant, and as a result, I think we are not able to, in fact, independently operate our own websites properly. We are too much dependent on them, and these are, I think, more severe consequences can be there. So I think these are some of the facts that Bhutan has not learned so far. Nobody has expected that Facebook will be down tomorrow, and everybody is on Facebook. But tomorrow, if anything goes down, and the more than anything else, if anything goes seriously wrong, Bhutan does not have a law that would protect our citizens, and as well as the government has no tools to, in fact, ask Facebook to do anything. Bhutan is a very small nation. These big tech giants will never take care about a country like Bhutan, where a population of less than 1 million. So I think these are some of the biggest challenges. And I thought I'll just share this one short story on that, and probably one day I may be able to share the full paper on that. Thank you very much.
Undoubtedly, Mr. Sonam sharing, we would be going with that paper also, where the progress of Bhutan is not only being described in such a way where the progress is mentioned through the pitfalls, through the major upcomings also, which we can enjoy ahead also, but certainly we go with this belief that soon everyone will be able to join through social communication, social media, and we'll be able to have all the grievances addressed in a better way. Thank you, Mr. Sonam Sharing. I would like to further invite Mr. Ranveer Kumar Singh, Director Unilegal LLC, Singapore. Mr. Ranveer obtained LLB honors from National University of Singapore and LLM from King's College London. Also obtained diploma in international arbitration from Chartered Institute of Arbitrations, UK, and graduate diploma in financial management from Singapore Institute of Management. Admitted to Singapore Bar in 1985, also admitted as Fellow of Chartered Institute of Arbitrators, UK. He has been in private practice since 1985 and has been handling a wide spectrum of legal matters. Frequently, he appears as a counsel in local courts, increasingly involved in cross-border legal matters, and has been involved in legal matters of Australia, India, Indonesia, Malaysia, New Zealand, People's Republic of China, Philippines, Thailand, UK, and USA. Further to this, he has been a lead counsel in a number of large and complicated cases and has argued many cases in the courts of Singapore International Court of Arbitration of ICC, Singapore International Arbitration Center, and Hong Kong International Arbitration Center. With this, I would like to have you on the same platform, sir. Mr. Ranveer Kumar Singh.
Thank you, Suparna, for the very kind introduction. We are having a very good afternoon here in Singapore. So may I wish all your audience a very good afternoon from Singapore. It's nice to be with MIT University again. I'm very thankful for the invitation again for the third consecutive time in your International Conference on Comparative Law. For today, I'd like to share with your audience some ongoing civil litigation reforms that is being done in Singapore. Right. So the civil litigation process in Singapore is being dramatically reformed. It is actually being drastic changes are being brought to the reform in order to make justice, access to justice much easier and also cheaper for the litigants. These reforms follow recommendations made by the Civil Justice Commission, which is constituted by the Chief Justice of Singapore, the Civil Justice Review Committee, which is set up by the Ministry of Law. The reforms are contained in the new Rules of Court 2021, which is slated to be effective from 1st April 2022. And this will be just food for thought for Indian law experts who are in terms of Indian civil procedure and for other countries as well. So we're just sharing with you. The rules of court will be supplemented by practice directions which will emanate from the courts. Now, let me turn to, there are, the bedrock of these new reforms are 5 ideals which the courts seek to achieve. 1, fair access to justice. 2, expeditious proceedings. 3, cost-effective work proportionate to 3 matters. 1 being the nature and importance of the action. Secondly, complexity of the claim, difficulty or novelty of issues and questions raised by them. Thirdly, the amount or value of the claim. And the 4th main principle, the efficient use of court resources. And finally, the 5th ideal is a fair and practical results suited to the needs of the parties. Now, one may think that these 5 ideals are nothing new, which actually they are not new. The problem has always been in achieving these 5 ideals in terms of the civil procedure. So often cases are delayed, proceedings get delayed, and access to justice becomes difficult and expensive as well. So at the forefront of this new reform is to achieve these five ideals, and this will be at the back of the mind of the courts and all the lawyers who are involved in the litigation. Now, let me now go and deal with some of those matters which have been set out in order to achieve these five ideals. How are we going to achieve them? Now, firstly, where there is an absence of any rule which governs any matter, the courts must act consistently with those ideals. This is clearly specified in the rule. In exercising powers, the courts may set aside conditions or give directions which are appropriate to achieving those ideals. In instances of non-compliance with any rule or any practice directions or order directions by the court, a court may dismiss or stay or set aside those proceedings and enter appropriate judgment or order, even if the non-compliance could be compensated by courts, especially if the non-compliance is materially inconsistent with any of the ideals. Now, one of the main changes that has been made is to shorten the time of the validity of originating processes. This is to ensure that originating processes are served on the parties expeditiously. The existing validity period for originating processes is 12 months. Under the new rules, it has been shortened to 3 months. In other words, the process has to be served within the period of 3 months. If not, one can seek an extension of time if there are good reasons for another period of 3 months. The only exception is for admiralty proceedings, where the existing validity period of 12 months is made. So this will certainly speed up the process of litigation. Secondly, insofar as pleadings are concerned, they can only be amended with the permission of the court or by the written agreement of the parties. And they cannot be amended within 14 days before the commencement of the trial. This is to ensure that no amendments are made very close to the trial and therefore delay the commencement of the trial. The existing position is that the pleadings can be amended once without permission of the court before close of pleadings, and thereafter with the permission of the court or by the agreement of the parties. So the new rules are geared towards ensuring that the trials do not get adjourned at the 11th hour because of amendments to the pleadings. Now, another major innovation is dealing with interlocutory applications. Usually in the course of the proceedings, multiple interlocutory proceedings are applied by parties, and that proceedings can end up with appeals and therefore severely delay the progress of the case. In these reforms, one of the major innovations which has been brought forward is having one single application pending trial, where in that single application, all the interlocutory reliefs will have to be sorted out. They may not be dealt with at one hearing because there could be a number of interlocutory reliefs being sought for. They could be dealt with over several hearings and over several judges, but they are geared towards speeding up the process of interlocutory proceedings and interlocutory relief which are being sought. So for example, addition of parties, division of issues, bifurcation of issues with regard to liability and damages, security for cause, further and better particulars, striking out the claim, all this will have to be sought out in one single application. The only exception will be, for example, for substituted service, or what one were to apply for an injunction, sort of Marewa injunction, or Anton pillar relief, or striking out the whole action, then those will be carved out from the single application pending the trial. So this is expected to speed up the process of the interlocutory applications and relief, and therefore bring forward the trial dates of cases. Another feature of the new reforms is the narrowing the scope of discovery and production of documents. Production of documents, as all litigators will know, and discovery process can take on a life of its own and result in and delay the progress of the case. Under the new reforms, the discovery will be guided by the 5 ideals, which I mentioned earlier, and 2 main principles. One, that the claimant should base its case on its own strength, not on the weakness of the defendant's case. Secondly, a litigant does not give up its right to privacy and confidentiality in its documents and communications. The court will only allow a broader scope of discovery if it's in the interest of justice to do so. For example, if it's necessary for the fair disposal of the proceedings. The new rules narrow down the scope of discovery, and the parties generally have to produce all documents which they are going to rely on, and also all known adverse documents. Beyond those, the court will have a discretion as to the scope of further discovery of documents. So therefore, this is a tremendous narrowing down of the scope of discovery of documents. Essentially, where documents will lead to a train of inquiry of other documents, they will not be allowed for discovery. And also parties who are internal correspondence will not be subject to discovery unless they are known to be adverse documents. Now, another feature of these new reforms is on the issue of witness statements. In some countries, this is relating to witness statements which are given by way of direct evidence or examination in chief. Some countries they call witness statements. In Singapore, we call the affidavit of evidence in chief, where all witnesses, whether of fact or expert, they have to give the evidence in chief by way of an affidavit, which are exchanged well before the commencement of the trial. The new reforms require parties, the court may require the parties to serve the affidavit, in other words, the evidence in chief of the witnesses, soon after pleadings have been served, well before the production of document stage. And the rationale for this is to avoid the possibility of witnesses tailoring the evidence to align with the documents which are disclosed. Secondly, this is to crystallize the key issues and streamline the matters which have to be considered in the single application for interlocutory relief pending the trial, which I mentioned earlier. And thirdly, this is also to reduce the scope of disclosure. So therefore, parties will have to gather all the evidence beforehand, before they even file their claim in court. Because of this requirement that they will have to file their affidavit together with the evidence in support of their claim soon after pleadings are served and well before the discovery of documents from the other party. Now, how these reforms will pan out, only time will tell. It will only start in April of this year. But I think one can be sure that it's going to speed things up, and certainly all litigants and lawyers will have to change the way they've been dealing with civil litigation and make sure they get the evidence upfront well before they file the claim in court. And that brings me to the end of my presentation, and I hope this will give some food for thought for other litigators, and I'll be happy to take any questions. Thank you very much for listening.
Thank you, Mr. Ranveer Kumar Singh. I really appreciate your efforts with reference to bringing the comparison together And being a teacher of civil procedure law, I am dealing with Indian procedural law, where we also consider the fair access procedure should be there. And for that reason, we also go with these ideals, which we have listed in 5 terms for the fair access, expeditious proceeding, leading to the cost effective and usage of the resources as per the needs of the people. I believe if we all follow these principles in our procedural way, certainly the notion which goes justice delayed is justice denied will not take place with us. Thank you, Mr. Ranveer Kumar Singh. Thank you so much. With this, thank you so much, sir. Due to some emergency, the prior commitments, we all were expecting Professor Rosalind Dixon, who is the Professor of Law in the Faculty of Law and Justice, University of New South Wales, Sydney, Australia. Unavoidable circumstances and certain commitments has led into this way where she is not able to join us, but the professor is being kind enough to share the message. I request you, sir, to kindly share the recorded message for us.
My name's Rosalind Dixon. I'm a professor of... Good evening. My name's Rosalind Dixon. I'm a professor of law at the University of New South Wales, Faculty of Law and Justice in Sydney, and I'm delighted to be joining this very worthwhile conference. My congratulations to Amity and Edith Cowan and all the other partners involved in putting it together and bringing together such a diverse range of scholars and practitioners from around the world. It's really a remarkable achievement. It's also especially welcome to have the opportunity to collaborate with South Asia and South Asian scholars in this context. South Asia is an deeply important region globally and particularly for Australia. And so the kind of collaboration that Amity and Edith Cowan have achieved is really valuable and important. As someone who grew up in Western Australia, it's also wonderful to see Edith Cowan's role in this collaboration and bringing a truly global discussion to a virtual audience, but also one connected to the Perth community. I regret that I'm not able to join you live, but other commitments mean that I was happy to join and look forward to hearing about others' papers at a later date. Before I begin my formal remarks, I want to just acknowledge that I'm recording this presentation from Bidjigal country in Sydney, and I want to pay respect to elders past, present and emerging, and to the Aboriginal owners of that land who have been amazing custodians of the beautiful land on which my office and home office are situated. So this conference is about comparative law and what comparative law offers us as scholars and practitioners in diverse fields and in diverse regions. I want to talk a little bit in my talk about why we might compare in a constitutional context and the different modes of comparison that are available to us depending on our role and position, as well as to offer some cautions about what is required to do comparison of each kind well. I think that the value of a discussion of this kind is to help situate some of the other papers that you'll be hearing that bring a rich contextual account of different aspects of comparative law and that provide a shared framework for discussion and evaluation of both the promise and pitfalls of comparative insights. In my presentation, I'm drawing on a paper that I have published currently on SSRN, although forthcoming in an edited collection, in honour of Professor Mark Tushnet of the Harvard Law School, who is one of the lead scholars and founders of comparative constitutional studies as a modern discipline. And I've asked the organisers to make sure that that paper is available to you if you're interested in reading it. So I want to suggest to you, first of all, that why we might compare can be answered by drawing our attention to 5 different modes of comparison, each of which has a somewhat different focus. So the first mode of comparison is what I would call borrowing or transfer oriented. Professor Henkin called this mode of comparison genetic influence. Professor Sujit Chowdhury has called it genealogical, where it is about a shared set of ongoing conversations among countries with common origins. Of course, India and Australia have that genealogical connection in ways that make this event especially interesting and valuable. The focus of borrowing is about making new constitutional text, about creating a new constitutional or amending it, or creating institutions that are in some other ways novel, even if at the sub-constitutional or quasi-constitutional level. The focus is on text, on structure, or on doctrine, but where it's on doctrine, the mode of comparison is somewhat different. It is a form of doctrinal comparison oriented toward understanding whether foreign systems have developed doctrinal solutions to a common doctrinal or legal challenge. As lawyers, we are quite commonly encouraged to practice doctrinal comparison in ways that are under-theorized and yet reasonably well accepted. The only place where this has been controversial is in the United States, where there tends to be a resistance to almost any form of comparison. So there is borrowing-oriented comparison that is focused on text and structure in the constitutional domain, or that is more doctrinal in nature. And the very fact of this kind of comparison at the drafting stage over time can give rise to an interest in ongoing genetic or genealogical comparison for those who are interested in constitutional history as a source of interpretation, a kind of originalist or genetic mode of comparison. Or on the other hand, a more common law style genealogical approach to saying how have these understandings that are shared across countries been understood in comparable, similarly influenced countries. That kind of genealogical approach is very likely to occur in a range of common law systems that share an Anglo-British heritage and where very canonical common law doctrines, habeas corpus, certain other writs might be the focus of comparison. The second mode of comparison I want to talk about is relatively uncontroversial. It's what you might call deliberative comparison. It's focused on arguments that have been presented and ventilated and canvassed in other countries in a common context. Sometimes those arguments might appear in academic journals. Sometimes they might appear in legislative debate. Or often they will appear in the pages of the law reports, but less in the judgments of superior courts or appellate courts, but more in the transcript of argument, where we see counsel, especially in an adversarial context, making arguments of a kind that may be of assistance to lawyers and judges elsewhere thinking through new issues that their own jurisdiction has not had multiple opportunities to test and consider argumentatively. So deliberative comparison is relatively benign from a perspective of any concerns about comparison and offers real promise, but promise that varies depending on how novel or different the issue is for a domestic audience. The more well-trodden, the less need there may be for a wide-ranging global deliberative engagement, whereas the more new, different or challenging an issue is, the more value there is to that kind of comparison. The third form of comparison I want to draw our attention to is what I would call empirical in nature. And this form of comparison is either thin or thick, but is ultimately oriented to understanding practices or consequences of various legal choices. So at the thinnest level, it is simply looking around the world to say, what are the possible range of choices available to us in this context? Should we ban something? Should we regulate it? Should we regulate it with certain conditions attached? And if you're the decision maker, legislative, constitutional, or judicial, you might look around the world just to see what the range of available alternatives are. That's the thinnest form of comparison that's empirical because it's simply about the existence of practices and not their consequences. But some forms of empirical comparison are thicker. They're more ambitious. They ask us to understand what causes things to arise or what comes out of certain doctrinal legal choices in terms of consequences. And this kind of comparison is more ambitious in what it requires of us as lawyers. The fourth and fifth mode of comparison are what I would call reflective and moral cosmopolitan, and they're ultimately focused on values as opposed to legal, doctrinal, textual, or practical consequences. They're about understanding ourselves, that's the reflective mode, as a people. As a constitutional polity, we understand ourselves better when we see ourselves in relation to others. This mode of comparison could be compared to travel, to looking in the mirror. Professor Frank Marquand at Harvard talks about this as reflective. Others think about it by analogy to a kind of critical self-reflection that is reflexive in nature. As scholars, as people meeting at this conference, we are all engaged in the practice of reflective comparison and learning from each other, not only about each other's systems, but also about our own. Because to understand our own system, we must be able to put it in some kind of broader context, to situate it, to position it, to understand how it differs as well as is similar to relevant comparative jurisdictions. Moral cosmopolitan comparison, on the other hand, aims not to unpack or understand particularity in our values or our approaches, but to identify common principles, universal ideas that transcend the particular context and are shared amongst a large number of countries worldwide. They might be all constitutional democracies or free democracies, all global South democracies or transformative constitutional systems. But there's at least a shared set of understandings and practices among those countries that give them a quasi-universal or generalizable quality. This kind of comparison can take two forms. One form, advocated by Professor Jeremy Waldron of NYU, is what he said a form of deliberative global comparison that generates something akin to a jus gentium, general principles achieved through global dialogue among equal partners. A very idealized conception of the world, perhaps, but nonetheless a very normatively desirable one. The second mode of moral cosmopolitan comparison is more statistical. It draws on the law of large numbers, the kind of ideas that Condorcet is associated with in the jury theorem context, and which Professor Eric Posner and Adrian Vermeule have developed in the comparative context to mean that the laws of nations might be representative of individual judgments by individual states as to what is right and good in terms of justice. Each of these modes of comparison, I want to argue, has value and is something to be encouraged, including by conferences such as this. But each has a particular focus: text, structure, or doctrine, history, perhaps, argument, consequences and practices, or values. And it's also important to understand what they demand of us in terms of the kinds of materials we are needing to look at. Borrowing-oriented comparison will tend to look either at the text of a constitution elsewhere or the decisions of other countries, as well as received understandings of how they've worked in practice in ways that meld into or blend into empirical comparison. Deliberative comparison, as I've said, involves looking at a select number of countries that have addressed similar challenges to see what arguments they canvassed. And it's perfectly appropriate and legitimate to look at the courts that have done the best job of thinking about the issues from an argumentative perspective. Empirical comparison, however, invites and requires lawyers to go beyond the textbooks or the case books or the law reports to see how things have worked out in the real world in practice. And that requires engaging with sociology, with political science, with economics, with econometrics, and the tools of statistical analysis and causal analysis that allow us to really understand whether if A came before B, A really did cause B, or whether they are simply correlated in a non-causal way. And I think empirical comparison is an underdeveloped aspect of our collective field, both as a scholarly and judicial and practitioner matter, but one that needs to be encouraged, but encouraged on the understanding that along with it goes certain disciplinary and interdisciplinary demands and challenges. Reflective comparison asks not a lot of us other than honesty and openness and a critical reflexivity around our own understandings and practices. In that sense, perhaps it asks the most of us. But moral cosmopolitan comparison demands the most work. It requires us to look at a large number of countries. And the tendency in historical context has been to equate a relatively small number of global north Western countries as representative of the globe when it comes to things like customary international law, general principles of international law, or the equivalent general principles that must guide a comparative moral cosmopolitan approach. Thinking about India's contribution to global knowledge and the contribution of many other countries in the global south forces us to remember that truly moral cosmopolitan comparison must grapple with large numbers of countries' experiences and choices. if not 190 plus, then certainly 80 plus constitutional democracies. And so it is not the most demanding in terms of orientation or psychology or even training, but certainly the most demanding in terms of workload. And it is not to be done lightly or equated with a casual glance across an ocean to one or two easily accessible comparable systems. Understanding comparison in this way shifts our attention from why compare generally to why compare in a specific context. It invites us to think more closely about who is comparing and for what purpose, and to ask more rigorous questions about the kinds of countries that are being considered and whether they are the right countries to be examined in order to answer the question that the lawyer or scholar is posing. So I am an enthusiastic scholar of comparative constitutional law who believes deeply in the promise of my field. But I also think that as we embrace its promise and seek to expand it across institutions and countries, we must be reminded of the rigor that is needed to do it well and to do it properly, and to train our students and our colleagues to understand that and to develop an appropriately rigorous approach to comparative constitutional studies. With that, I hope that I may have contributed to the discussion more broadly and that you will continue to have a stimulating and enjoyable conference.
Thank you so much, sir. Professor Rosalind Dixon cannot be left with just an introduction unaddressed. So going with her introduction to the contribution which she has done towards the conference and towards the society, let me go with this, that Professor Rosalind Dixon is a professor of law at University of New South Wales Faculty of Law. She has earned her BA and LLB from University of New South Wales and was an associate to the Chief Justice of Australia, the Honorable Murray Gleeson AC, before attending Harvard Law School, where she obtained an LLM and SGD. Her work focuses on comparative constitutional law and constitutional design, constitutional democracy, theories of constitutional dialogue and amendment, socio-economic rights and constitutional law and gender, and has published in leading journals in US, Canada, the UK, and Australia, wherein the Chicago Law Review Journal, GW Law Review, and many more to her contribution. This is a short introduction of ma'am where she has elaborately dealt, where her contribution, the recorded message, is being taken up so lightly that it has led us to rethink on comparison of law in terms of justice, in terms of democracy, honesty. Thank you so much, ma'am. With this, we'll go with the citations. I would like to go with the citation. May I request sir to go on with it? Thank you so much, sir. This citation is presented to Professor Rosalind Dixon in absentia over here in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Professor Dixon is a legal scholar with acumen specializing in comparative constitutional law and constitutional design. An erudite personality with vast knowledge and experience, Professor Dixon has immensely contributed to this conference by her thought-provoking words. We are beholden to Professor Dixon for sparing her precious time and adding value to this conference. We hereby recognize the contribution made by Professor Dixon and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. I again extend a warm gratitude to her who has led into the contribution of a recorded message. Thank you. Further with this, I go on with the citation of Dr. Subhajit. This citation is presented to Dr. Subhajit Basu in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Dr. Basu is a legal scholar in information technology law and has contributed immensely to the field of internet privacy, regulation, and data protection. A prolific speaker and academician with the urge to contribute to the emerging areas of law. We extend our gratitude to Dr. Basu for gracing this occasion. We hereby recognize the contribution made by Dr. Basu and extend our heartfelt thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. I seek your...
Thank you so much. Thank you so much for your invitation. I'm looking forward to interacting with you in the physical world. I've been to Amity before, to your school in University in Noida, and I hope to do it soon in forthcoming future. Thank you. Thank you so much.
Thank you. So nice of you, sir. I would like to go with the citation ahead. This citation is presented to Mr. Sonam Sharing in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Mr. Sharing, a researcher on Bhutanese laws and has worked extensively on contractual and procedural laws. His scholarly acumen is a remarkable and brings forth a cultural diversity. We are extremely thankful to Mr. Sharing for gracing his occasion and sharing his valuable insights with us. We hereby recognize the contribution made by Mr. Sharing and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. So,
thank you very much. Thank you, Amity Law School. Thank you, Edith Govin. And we wish to continue conversation with Amity School. And Bhutan is not far away from Amity School, so I definitely would love to visit the school. I have not been able to visit the school. So thank you very much.
Thank you so much, sir. Further to this citation is presented to Mr. Ranveer Kumar Singh in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Mr. Singh has rich experience of litigation in varied arenas of law, including business laws and merger and acquisition and arbitration. He is a legal luminary to reckon and has a zeal to bring change to society. We express our hearty gratitude to Mr. Singh in our midst, who has always wholeheartedly supported us in all our endeavors. We hereby recognize the contribution of Mr. Singh and extend our heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you, Suparna, for the very kind words, and many thanks to MIT University and Edith Cowan University as well for this citation. I'm really happy to have played a small part in your conference. I'm also very happy to see on the screen some familiar faces, Professor Aditya Tomar and Dr. Sumitra Singh. I met them on my last trip to MATU in Noida a few years ago. Unfortunately, due to the COVID, we've not been able to travel much, but I'm really glad to be able to be connected, at least through this platform. Thank you very much, and all the best.
Thank you very much, sir.
With this, I would like to go with the further citation. So, am I audible? This citation
Yes, ma'am, you are audible.
Okay, it's not going here. The citation is presented to Mr. Amir Faruqi in the keynote session of the International Conference on Comparative Law on Saturday, the 19th day of February 2022. Mr. Faruqi, a legal counsel at the French Embassy in India. He is an expert in French laws and has contributed immensely to the conference. We hereby express our gratitude to Mr. Faruqi for his support in this conference. We recognize the contribution of Mr. Faruqi and extend our heartfelt gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. So, with the message in the chat box, he has apologized that he couldn't continue with the same, so he had to leave. And with this, we come to the vote of thanks. It is indeed a privilege to propose a vote of thanks. Indeed, a privilege to propose a vote of thanks and acknowledge the contribution of our learned honorable speakers, Dr. Subhajit Basu, Mr. Amir Faruqi, Mr. Sonam Shering, Mr. Ranveer Kumar Singh, and the recorded message was so lively of Professor Rosalind Dixon. Today, we all had an opportunity to hear your thoughts, and this will surely be going to encourage us in our lives. Where Dr. Subhajit Basu highlighted the data privacy with live examples of Facebook to Meta, the parent company, and Instagram, amongst other examples. He emphasized on the powers which are vested with the companies in its disclosures, and this leads to the control of all, which has the influencing power. Further to it, the lack of oversight mechanism in transparency and coherency, which can take a new dimension through competition law and data protection, was being highlighted by the sir. I'll go with the further where Mr. Amir Faruqi also enlightened us where the contract clause, which is a major part in force majeure, has led a new dimension in the times of pandemic COVID-19, where the acceptance was being made on the relevancy of comparative laws. He focused more on the arbitration when it comes to cross-border transactions for seeking compensation and damage when the contract gets frustrated. With the further contribution of Mr. Sonam Shering, where he expressed the progress of Bhutan from its initial period to the pandemic situation where COVID-19 has made everyone dependent on the social media. Thank you so much, sir. We have Mr. Ranveer Singh also, where we went with the fair trial procedure where the ideals have to be adopted, where the assurance should not be just left on a piece of paper, but also to be enjoyed for all the times. By giving the principles, we also go with the taking of evidences on affidavits and restricting the number of amendments for the speedy justice. Thank you so much, sir. Where Professor Rosalind Dixon highlighted the need of comparison on laws in relation to consequences which can lead to different understanding. I extend my gratitude to all the dignified learned speakers and Tomar sir over here. Thank you so much, sir, for giving this opportunity where we can have this dimension of comparison law with reference to every single domain, which is leading to the need of the society at the present hour. Thank you so much, sir.
Thank you, Dr. Suparna. I personally want to thank to all the speakers. Thank you very much that you spare your valuable times from your busy schedules. Thank you, Dr. Subhajit, Ranveer, sir. Thank you very much. Dr. Sonam, thank you very much. And our dear friend, Dr. Joshua.
Thank you, sir. It's really been a pleasure listening to each and every one of them and different perspectives that they brought in, the expertise that they have. It's been wonderful listening to them. Very powerful. Thank you.
Thank you so much, sir. Thank you, Aditya Thomas, sir. And a heartfelt thanks to the organizing team and IT, where the things led into so smooth and successful event. Thank you so much, ma'am. Jane ma'am, Priyanka ma'am, Rupinder sir, Sakshi ma'am. Thank you so much for all this opportunity where we all can come together on this diversified topic, which was required at this stage. Thank you so much. Thank you, audience.
Thank you.